The process of ijtihad covers the entire range of interpretation undertaken for deriving legal rules that are to be followed by Muslims as individuals and as a community. At one end of this range is literal interpretation of the legal text along with the derivation of implied meanings during such interpretation. This is followed by analogy and istihsan. In all these forms of interpretation, the texts of the Quran and the Sunnah maintain complete hold. At the other end of this chain of methods of interpretation comes a method called Maslahah Mursalah. This method begins where individual texts have released their hold, and the issue at hand is released into the realm of the text taken as a whole. By release into the fold of the text as a whole, we mean at least two things. The first thing is that there are no fixed rules or individual texts that are related to the issue that we are examining. The issue has been offered, so to say, to the discretion of the judge or jurist. Is this discretion uncontrolled so that the issue may be decided according to whatever the judge or jurist thinks should be the governing Islamic norm? This takes us to the second meaning of texts as a whole. The texts as a whole have come to mean, through the tremendous hard work and labor of the jurists, the Maqasid al-Shariah, or the purposes of the law. The purposes of the Sharia are in reality ultimate general principles, derived on the basis of induction from the texts of the Quran and the Sunnah, with the help of the rules and principles emerging from them. Each ultimate principle, or purpose as it is called, governs an unlimited number of cases that may arise today or in the future. These broad general principles are ultimate interests or values that help regulate judicial discretion. The discretion of the judge cannot move beyond the boundary conditions established by these principles. The purposes of the Sharia cover not only individual cases to be decided through judicial discretion, but also general principles called Qawaid Fiqhiyyah. These principles have also been derived through induction from smaller segments of individual cases. Some of these qawaid may also be provided directly by the texts of the Quran and the Sunnah. Groups of related principles may be gathered together and classified under the relevant ultimate principle or purpose. Thus, for example, all those qawaid that pertain to economics, finance and property may be classified under the purpose called protection and preservation of property. The way these Qawaid Fiqhiyyah and purposes operate to guide judicial discretion is perhaps the same as what Ronald Dworkin has to say about the role of principles in settling hard cases in Western law. The principles are those which the Anglo-American civilization has upheld from the start. The same may be said about those who uphold universal principles of natural law that are based on human reason. In the same way, the Islamic system of judicial discretion is based on the Qawaid Fiqhiyyah and the Maqasid al-Shariah. The Muslim jurists have, therefore, designed a perfect system of administering justice in the area in which there are no fixed rules. It is a system in which the guiding principles are clearly identified. Remaining within the boundaries of these principles and observing the conditions pertaining to the use of Maslahah Mursalah will ensure that all new cases are settled in accordance with the norms of Sharia.